Judges back in the chambers, or back in court. Okay, quick sidebar. This is what typically happens whenever they come back in. There is just some manners of business that they want to take care of. The matters of business in this instance likely still focus on the pictures. That was the big debate, the pictures that came in. Could they still be discussing, hey, wait a minute, we need to get more of these pictures in, I'm going to use more demonstratives, or what would you think this is all about?
Well, that may well be. Certainly the court doesn't take business in advance as to what is the immediate need to talk with these lawyers, and the immediate need obviously relates to this witness and the exhibits that are now being offered into evidence by the defense.
Interesting that the one thing that was not shown by Mark O'Mara, even though he got the witness that's on the stand still, Jeannie Nanalo, to say that she was basing it on the hoodie picture at first and then the football outfit that he was wearing, he didn't then present those in his evidence. Or is that because they're already in his evidence, or why did he not at that point say, is this the picture you're referring to?
Well, I don't think that they're in evidence at this point. If it's not, if an item is an exhibit, you can use it in a certain fashion, but you can't really use it to its fullest unless it's admitted into evidence. So there's still this issue of whether or not these photographs are going to be entered into evidence for the jury's consideration.
Mm-hmm. Some folks want to know what's the scene like here in Seminole County. What we can tell you, of course, a packed courtroom, much more intimate at times, to your earlier point about just how close they are sitting to the Trayvon Martin family, the jurors, and George Zimmerman's not that far across the room. In the Casey Anthony case, we would see her shrink in her chair, and many commented that she was even lowering her chair where she could almost hide behind some of the computer screens, many times out of clear view of people in that court, because that was a massive court, maybe 3 times as big as the one courtroom 5D.
Yeah, I think it was about 3 to 4 times larger. And don't forget, you had a viewing gallery from above in that courtroom. And yeah, you know, we talked about that, and obviously it was a defense strategy to make her look small, insignificant, and vulnerable, and they did obviously a nice job doing that.
Sidebar over, back to courtroom 5D.
Get a few photographs and see if you had recognized any of those. Okay?
Yeah, just so we're clear, just state your name again.
Jeannie Nanalo.
Still under oath from having testified this morning?
Yes.
Great. I have a few questions and pictures to show you in reference to what your testimony was before. I'm going to start this way. I think it might be most relevant. But let me ask you, what I would like you to focus on for the purpose of these questions is in reference to the comparison that you made in your mind regarding the relative size of George Zimmerman and Trayvon Martin. You had said you looked at pictures of Trayvon Martin, correct? You were to make that determination?
I didn't look at pictures. I saw it on the TV.
Pictures on TV?
Yes.
Okay. So the purpose of these questions right now are to see what pictures it was you remember looking at as part of your foundation for comparison, okay? You've seen that photograph?
Yes.
Okay, and this was one of the ones that you used for your comparison?
Yes.
Okay. And I'm sorry. She's identified Defense Exhibit U for identification purposes. Not this photograph.
Yes.
This was one that you used. And that is Defense Exhibit S. And how about this photograph?
Yes.
Another one that you used for your comparison? Defense Exhibit T. And this photograph?
Yes.
And this you used for comparison purposes?
Yes.
That is Defense Exhibit V. V as in Victor, sorry. This photograph?
No.
Never saw this photograph. Well, strike that. Did not use a photograph like this for comparison purposes.
I didn't see that photograph.
Okay, sorry. this one?
No.
Similar short
No.
crop of the other one?
No.
For this limited purpose, Your Honor, those are the only.
May I inquire?
Yes, you
just
may.
that very limited. These photographs that were shown to you by Mr. O'Mara now, did you see these prior to saying that there was a weight difference or build difference between Mr. Zimmerman and Mr. Martin? Or was this after? When was this asked? When did you see these photographs in relation to making the statement that there was a size difference between Mr. Martin and Mr. Zimmerman?
When did I see the picture?
Yeah, did you see those before or after?
After. After.
After what?
After. I saw
After
it in
the
the
event.
news after the event.
Okay. Did you see those, okay, after the event?
Yes.
And prior to making a statement that you made where you said there was a weight difference or a height difference between the two individuals?
Yes.
Okay, thank you.
No further questions for the proffer of sorts. I think we're ready for the jury then.
Okay, which, are we ready to bring the jury in?
I believe we are, Your Honor.
Okay, let's go ahead and bring them in.
Time of the jury is present.
Please be seated. Good afternoon, ladies and gentlemen. And while you're settling in, I'll go ahead and ask you my questions. During the lunch hour, did any of you, and if your answer is yes to any one of my questions, please raise your hand. Did any of you during the lunch hour have any discussions amongst yourselves or with anybody else about this case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use an electronic device to do any independent research about the case, people, places, things, or terminology? No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? Thank you. No hands are being raised. Ms. Nanalo, I'll remind you, you're still under oath, and Mr. O'Mara, you may continue.
Thank you, Your Honor. Again, ma'am, good afternoon.
Good afternoon.
Before the lunch break, we were talking about what you used to come up with your opinion that there was a size differential between Mr. Zimmerman and Mr. Martin, correct?
Yes.
And we talked about some photographs that you viewed. Is that correct?
Yes.
I'm going to, if I might, Your Honor, since they've been previously identified, I was going to put them on the screen for her to identify. But no, I'm sorry, let me do it
I
in
didn't
front
know
of the
if you're
jury.
Are you moving them into evidence? And is there an objection?
I would move the entirety of what's been previously identified in the proper evidence, Your Honor.
And that would be which letters?
Those were...
S, T, U, and V?
Yes, Your Honor.
Any objections?
No objection, Your Honor.
Okay, S will come in as defense exhibit number 2. T will, 12. T will come in as defense exhibit 13, U will be 14, and V as in Victor will be 15. You were going to put them up? You want the lights down?
Yes, if you would, Your Honor. Hold on. Why would I press the button? Thank you. Sorry, Your Honor. Can you see that screen?
Yes.
Is this one of the photographs that you looked at in coming up with your sort of description of a difference in size between the two?
Yes.
Do you identify that as both a regular and then photoshopped picture of Trayvon Martin?
Yes.
Would you agree that that is, as we talked about earlier, simply a shoulder and head shot of Mr. Martin?
Yes.
Can you see this photograph? Yes, it is. It's slightly different, John. Let me just get the right one. Maybe some help. And I'll do this one next, Your Honor. Why is it not the same? You may recognize this photograph.
Yes.
Is this a photograph that you used to help you in your comparison between Mr. Zimmerman and Mr. Martin?
Yes.
Is it?
Yes.
Okay. You give me a guesstimate of the age you think the person in that photograph is?
11, 12?
Okay. And how about this photograph? Recognize this photograph?
Yes.
And this was also one that you used in your comparison between Mr. Zimmerman on the night of February 26, 2012, and Mr. Martin, correct?
Yes.
What's your guesstimate as to how old that person is?
16?
If I might approach the witness, Your Honor, just to make sure we have the proper...
Take that down.
Yes.
Thank you. Let me show you what's been now entered into evidence as defense 14 and ask if you can identify that photograph as well.
Yes.
And is that also a photograph of Trayvon Martin?
Yes.
And also one that you utilized in making this comparison between Trayvon Martin's relative size and George Zimmerman's relative size?
Yes.
And I would like to publish this to the jury.
You may do so. Your husband had taken a photograph of George Zimmerman's injuries that night, did he not?
Yes.
And you've seen that photograph, correct?
Yes.
I believe that was licensed to ABC, correct?
License to ABC.
Wasn't it sold or licensed to American Broadcasting Company? That's how they got the picture?
I don't know.
Okay. If I might approach the witness.
Yes, you may.
This is in evidence as Exhibit 76, Your Honor.
Okay, there's an objection.
For relevance, I don't believe. I don't want to make a speaking objection.
Okay, please
We
approach.
Craig Wormuth with legal analyst Bill Schaefer. You heard Bernie De La Rianda, the state attorney's office, now saying he doesn't want to make a verbal objection. Why is that?
Well, the court has limited the attorneys to non-speaking objections. What does that mean? Quite simply, it means you have to state the legal basis for your objection, but not argue or provide any argument to supplement your legal objection. Example, hearsay. Anything other than hearsay is a speaking objection as to support your objections to hearsay. So he wanted to say, for example, hearsay, and tell the court why it was hearsay.
Okay, so that's over. Let's listen and see what was decided.
Did you see these injuries?
No.
Did you see them any time from the photograph that night? Did your husband, for example, show you
No.
the injuries? When was the first time you saw this photograph?
A few weeks later.
Thank you. You had testified earlier, I think. You understand that Mr. Zimmerman's on trial for second-degree murder, correct?
Yes.
Okay. And you had testified earlier that as far as the size or the comparison of the two people, at first you testified that you can only see shadows, correct?
Yes.
And then you testified that you, as to the size comparison, you could have been mistaken. Is that correct?
The only way I can find out for now if I can see Martin's recent picture.
Yes, ma'am. Then, Your Honor, with that in mind, I'd like to have a moment. You may need to address this first at the bench, Your Honor. I don't want to show her something until that's
I
been
think you need
accomplished.
to show it to counsel first.
This was marked and previously given to him just a couple minutes ago, but I'll show it to him again, Your Honor. First, the witness, Your Honor?
Yes, you may. You want to show counsel first?
Yes, this is in evidence as States 45.
Yes, you may approach.
Let me show you a copy of evidence, State 45. Ask if you can identify that person.
Yes.
Let me show you what.
I will object to the second part. I have no objection to the first photograph.
That's what I thought we should approach before.
I think you need to show what you intend to show her to counsel first,
I
and then
did.
if you need,
I have no objection to the first photograph that Mr. O'Mara showed, which is a picture of Mr. Zimmerman. I do have a second regarding the second photograph.
could you tell me what the letter is for that one?
Yes, Your Honor, it is identified as R for identification purposes.
Okay, and the court has previously ruled on that. My ruling stands.
And I would like to be heard on that further because now that the witness has identified the request to make a comparison in court, I would like to be heard on that. If I may.
That was shown to this witness, and she said she did not recognize it. So that's the basis for the court's ruling. If you want to show her a picture that she said she recognized, which would be defense exhibits 12, 13, 14, and or 15, for her to make that comparison, you may do so. They're in evidence.
May I be heard at the bench?
Yes.
Okay, the debate now is on regarding pictures of George Zimmerman being presented to the witness who described the person that she thought was bigger based on pictures she had seen on the news, and those were the pictures that she admitted were much younger versions of Trayvon Martin.
The objection to this photograph was based upon the fact that the witness said, no, I've not seen this photograph before, much less did I see it before, making that comparison in size based upon photographs. So If she didn't see it before, and that wasn't a photograph she used to make her size comparison, then it's not relevant and should not come into evidence now unless there's some other basis or a predicate is laid for the admissibility of that photograph. It should not come into evidence.
So she has seen the picture now, but again, and the jury has seen this picture, this was presented to them a couple of days ago. This may not be able to be used as the description because she had no knowledge of this when she based her decision on who was on top and who was on bottom during the scuffle.
Right, and by the way, the defense wants this picture in because it shows injuries to George Zimmerman, so it serves a dual purpose in their plans to get this in.
I think it might even serve a threefold purpose. It also shows how much smaller he was at the time in 2012 to what he is today, well over 100 pounds heavier, so it appears.
Oh, that, and by the way, the photographer shot it. It looks like a downward shot, which always makes you look smaller. I always tell the camera, don't shoot me down, don't make me look small. So it might have a fourfold purpose then, you're right.
So as we look at what is happening in courtroom 5D, another sidebar, it goes to show you mentioned earlier this morning that objections and sidebars show the importance of this particular witness.
Yeah, they're really scrapping over this witness, and it's important that they do scrap over this witness because she had some pretty critical testimony to the state and testimony that was critical to the defense to cast some doubt on its reliability.
What about the sidebar that occurred and then they moved on after the sidebar with no more talk about a picture that was allegedly sold to ABC?
Well, because the witness testified that she used that picture or saw that picture in making her analysis.
All right, let's go back to courtroom 5D.
Ma'am, even with the request to make a comparison between two current photographs of the two individuals involved, presuming that you're not going to do that today, would you acknowledge that your comparison of the relative size of the two individuals was based upon the aged photographs that we've just reviewed?
Yes.
And that alone? And that, in effect, you were comparing Mr. Zimmerman, this person, right? This is the Mr. Zimmerman that you saw that night, correct?
Yes.
And we reference 45, Exhibit 45. You're comparing him to the football picture, correct?
Yes.
And to the hoodie picture, correct?
Yes.
And to the other football, the even younger football picture, correct?
Yes.
You have not seen any current photographs of Mr. Trayvon as he existed that night, have you?
That's correct.
Have you had a chance to review the video of the 7-Eleven that was now in evidence?
No.
Might just have a moment. Just one or two more. So in sum, you were in the house and heard various occurrences outside that caught your attention.
Yes.
Howling, there was some noise. You went outside and saw another neighbor whose name you don't know across the way looking at the two individuals on the ground.
Yes.
You heard a shot, correct?
Yes.
You went outside and you saw a person walking about. Is that accurate?
I didn't go outside. I just looked out.
And I apologize, I said that now a second time. When you looked out, that after the shot, you saw somebody lying on the ground,
Yes.
and you saw somebody walking around,
Standing up, yes.
standing up. Did you see that person walk around at all?
I don't remember.
At some point, your husband then went outside, correct?
Yes.
Did you see that person who was standing up talking to your husband?
Yes.
Okay, so the person who was standing up earlier was the person talking to your husband, correct?
Yes.
who you know to be George Zimmerman.
Yes.
But you're not certain, as you sit here today, who was where in that altercation, are you?
No.
Because your sole comparison was the 12-year-old picture?
Yes.
Thank you. Nothing further on.
Thank you. Any redirect?
Based on your determination of height and weight and build, were you comparing the two out there?
Yes.
And based on what you saw on TV, forget about how old the picture is of Trayvon Martin. If you were to hear that he only weighed 158 pounds, and Mr.
Thank
Zimmerman,
you, Your Honor. That is...
I'll be glad to rephrase the question.
Okay.
Did you believe Trayvon Martin was skinnier and smaller than George Zimmerman?
Objection, Your Honor. Improper predicate. She's testified. I don't want to speak to the objection. Improper predicate.
Overruled. This is redirect.
Mr. Zimmerman, based on what you observed, was bigger than the other person, correct?
Objection, Your Honor. Leading.
Sustained.
You've already testified in direct testimony and in cross-examination that Mr. Zimmerman was the bigger of the two individuals, correct?
Objection, Your Honor. Asked and answered.
Overruled.
Mr. Zimmerman was the bigger of the two individuals you saw out there, correct?
Objection, Your Honor. That is a mischaracterization of the evidence.
Okay. Overruled. She can correct whatever testimony she believes is not being stated correctly.
I'm sorry.
Mr. Zimmerman was the bigger of the two people out there, correct?
Comparing the picture, yes.
Okay. Now, you were asked about the comparisons. Mr. O'Mara asked you about interviews you gave to the police, remember,
Yes.
to Detective Serino, and then also to FDLE?
Yes.
Okay. And Mr. O'Mara asked you about the interview you gave to the FDLE. I believe that's, Madam Clerk, may I? Yeah, defense exhibit that was shown. Thank you. Believe, may I approach the witness, Your Honor?
Yes, you may.
Defense showed you exhibit Q. Remember looking at that interview that you gave to Detective Crosby with FDLE on March 20th? Remember looking through that?
Yes.
And you remember Mr. O'Mara asking you about, did you ever talk about a description of the individuals you saw out there? The person you saw stand up after the shooting, the person you saw on top?
Yes.
And you stated specifically that they never asked you to describe the size of that individual. Do you recall that?
Yes.
Okay. Now, isn't it true, ma'am, that 6 days later, and if I may approach the witness, Your Honor, and mark this for identification.
You want to show it to counsel?
I apologize. It's the sworn statement you gave me on March 26th.
I would object to improper bolstering of the witness. That was never crossed on in cross-examination. I just have identified.
Okay. Let him mark it for an exhibit and approach the bench.
And again, listening into Judge Deborah Nelson asking the attorneys to approach the bench, the debate over pictures and how she made her comparison, and then talking about the weight and the size of Trayvon Martin.
Yeah, again, the significance of this witness's testimony is underscored by the number of objections, as you have observed earlier, and how long she's been on the witness stand, and the attempt of the prosecutor to rehabilitate her